Testamentary jurisdiction of the ecclesiastical courts. Chapter 1. Testamentary jurisdictions. The manner in which probates and administrations first became subject to the jurisdiction of the Church, seems to be a matter of dispute, but we find in Magna Carta, that the goods of intestates should be distributed among their relations provision ecclesi, which may be deemed to be either a grant to the Church, at that period, of the superintendence of the distribution of the intestate's effects, or otherwise as an acknowledgment that the Church already possessed such power. But to avoid any difficulty in defining the meaning of the words provision ecclesia, a reference to certain canons made in 1240, will explain that the will is there ordered to pass under the view of the bishop, or provision episcopi. In 1248 another style came into use in the probates of wills, viz. Prelatus Sius, Episcopus Sius, and Ordinarius. And in the provincial constitutions of 1261, Ordinarius loci is often to be met with, as likewise in the Council of Dublin, about 1217, and in the Scotch Provincial Synod, about 1225. It was also the language of the canon law. And by the General Council in London, in 1268, the appropriation of this jurisdiction to the ordinary of the place, seems to have been provided for in exclusion of the prerogative. We ordain that the testament of him, who had, whilst he lived, benefices in divers dioceses, shall be proved by the bishop in whose diocese the testator died. After this, several of Henry III's confirmations of the Great Charter, wherein are reserved to the prelates the liberties and customs which they had in times past, came in aid of the diocesan's right, and it may deserve observation that in the ensuing controversies, the suffragans laid great stress upon this, that, by the custom of the Kingdom of England, the probation of testaments and administration of goods, belong to the ordinary of the place, in each diocese of the province of Canterbury. Nevertheless, this foundation was not strong enough to discourage Archbishop Beckham to attempt to subvert it by legating omnipotence, for it was in express terms, jure legationis, and not as metropolitan, that he claimed this controverted jurisdiction, the not being wanting precedents of His Holiness's intervention in testamentary dispositions, to countenance his legate's claim to it. Alexander III granted, about the year 1175, the effects of deceased clergymen, within the province of York, to Roger, Archbishop of that see, and in 1246, Innocent IV seized the estates of Robert Hales, Archdeacon of Lincoln, Almaric, Archdeacon of Bedford, and of John Hotosp, Archdeacon of Buckingham, granting, about the same time, a general commission to the Minorite friars, to sequester the goods and chattels of intestate laymen, as well as clergymen, in exclusion of the next of kin. Against a grant of this kind from the Pope to Henry III, the proctors of the Diocese of Lincoln articled in the Parliament of 1255, in the following words: "They are so disquieted, because their legacies, which ought to be distributed according to the will of the deceased to the use of the poor, their parents, and servants, and to other pious uses, are granted to the king for other purposes, contrary to the will of the deceased." And among other indulgencies to laymen, issued out of the chancery at Rome, one was, that executors might retain those goods, which by the wills are directed to be distributed amongst the poor, so that the articles of impeachment against Wolsey, that by his authority legating he had taken the goods of deceased clergymen, by reason whereof their wills be not performed, was a description of such exorbitances as legates had commonly been guilty of, and were authorized to perpetrate. Neither is it wonderful that the Pope, who looked upon himself as Lord of the universe, and had distributed provinces and even empires, should disregard the rights of the dead, who cannot complain, or the fences of private property. From this fruitful root, the prerogative of Canterbury made frequent shoots, there being no one rule more steadily observed by the metropolitans of that see, than that it was their duty to imitate the Roman pontiff in the use of that power they derived from him. Accordingly the controversy sprouted out again about the year 1300, between Archbishop Winchelsea and John Dalderley, Bishop of Lincoln, but came to no conclusion, the Archbishop being disabled from carrying it on, by the displeasure of Edward I, who compelled him to leave the kingdom. However, it was soon resumed by his successor, Walter Reynolds, and about 1319, terminated by his entering into a composition with the same Bishop of Lincoln, which not only acknowledged the exclusive rights of the bishops of Lincoln to the grant of all probates and administrations when the deceased had goods only in the diocese of Lincoln, but also when they left goods in divers dioceses, and in reference to the 92 Canon, it will be found to be one of those compositions between the archbishop and bishops which were exempted from the operation of that canon, and this composition was constantly acted upon, not only in granting probates and administrations when the deceased left goods in other dioceses, but there are entries in the registry of Lincoln, from 1345 to 1624, of decrees by the Bishop of Lincoln for the revocation of probates of wills, passed in the Prerogative Court, in which there were goods in different dioceses bequeathed, and the probates were afterwards granted by the Bishop of Lincoln according to the composition. But that the general power of granting probates and administrations resided in the bishops, is fully established by the decree of the Council of 1368, over which John Stratford, the then Archbishop of Canterbury, presided, the testaments moreover being proved and approved before the ordinaries of the places, to whom the probation and approbation of testaments belong. Nor was there in any canon made then, or at any other time previous to 1603, any reservation, or even mention of any prerogative right of the Archbishop of Canterbury, to prove wills where the deceased had goods in divers dioceses. But although the composition regulated the jurisdictions of the Archbishop and Bishop as far as regarded the Diocese of Lincoln, the other parts of the province had not a long respite, for in 1384 and in 1400, this matter was in contest between the Archbishop and Bishop of Exeter, and in 1414, certain commissioners appointed by Hen. v. to inquire into the state of the Church, represented this prerogative assumed by archbishops, as a common grievance to the subject, as well as the ordinary. Article the 31st, concerning the prerogatives of the churches of Canterbury and York. Wherefore the prerogative of the churches of Canterbury and York, which was never founded on right, has very much unsettled the jurisdictions of the inferior bishops and other ordinaries, by unnecessarily troubling the persons living within them. Wherefore many things at variance with what is right have been the consequence, and the powers given to the ordinaries have been impeded in their regular exercise. And upon this consideration it was judged equitable, in the year 1707, to relieve the widows and orphans of persons engaged in the government dockyards, from the inconveniences to which they were subject by contentions between the prerogative court and the ordinary jurisdiction. And the Act of 4 and 5 Ann was passed to direct that the probates of the wills, and the letters of administration of the goods and chattels of such persons, should be granted by the person, to whom the ordinary power should belong, where the party should die, and that the wages due to such party should not be considered bona notabilia to found the prerogative upon. About the year 1494, Pope Alexander IV, induced, as he was pleased to declare, by no other motive than his own knowledge of the benefits accruing to the province from it, repaired the jurisdiction of the Prerogative Court of Canterbury by a new grant of privileges, in respect of testamentary cognizance. In this bull there were two very significant clauses. The first was a clause to supply all defect of fact as well as of law. The preamble of the bull suggested that the archbishops had immemorially enjoyed the privilege of taking probates of wills, when the effects bequeathed were in different dioceses, lest, therefore, the notoriety of the falsehood of that suggestion should invalidate the grant, it was found advisable to provide a supplement for truth. The second was a general non-obstante to any authority that was contrary to this concession, and particularly to the Constitution of 1268, about the probate of the will of a pluralist, which has before been set out at large. Upon this accession of strength, Archbishop Morton resumed the exercise of his prerogative with fresh vigour, and by the terror of excommunications and other censures, which he fulminated with great profuseness, drove his comprovincial bishops, their archdeacons, and the possessors of testates and intestates effects in crowds into the prerogative court, where he made himself judge of the rights in controversy between the prerogative court and the diocesan consistories, and pronounced for his own jurisdiction. Against these violences Richard Hill, Bishop of London, remonstrated to the Pope, as did likewise William Wareham, his successor in the See of London, opposing the extension of the prerogative with more spirit than foresight. For he who had been the most strenuous advocate for diocesan rights, was no sooner exalted to the primacy, than he carried his prerogative with a higher hand, and gave greater encouragement to the encroachments of his officials than any of his predecessors had done. Wherefore, all the suffragans of the province concurred in a synodical complaint against him in 1512, and upon his refusing to comply with sense of the synod, applied to the Pope. The following items are from the synodical complaint of the suffragan bishops. In the first place, the suffragans asserted, as a fundamental point, and were ready to prove, that by the custom of the Kingdom of England, the probate of testaments is of ecclesiastical jurisdiction, as well from the constitutions of the province of Canterbury, as of Octobon, formerly the legate of the Apostolical See, and, in each diocese of the province, the probate of wills and administration of goods of persons dying belonged to the ordinaries of the places where they died, from which it followed that the archbishop, pretending a right of proving the testaments of persons dying within the dioceses of the suffragan bishops, and leaving goods in divers dioceses, could not establish his claim upon a prerogative or privilege, unless he could found it upon some special right. They, therefore, besought the archbishop that he would deign to declare the nature and description of such prerogative, if any such there were. To which petition the archbishop refused to assent, desiring rather that his pretended prerogative should remain in doubt, that he might at pleasure usurp the rights of his suffragans. The suffragans also complained that the officials and officers of the archbishop pretended that persons dying had goods in divers dioceses, when, in fact, they had not, and under colour thereof proved the testaments of deceased persons, when they had no right of proving them, and when the right belonged to some of the suffragans or their archdeacons. And that a writing, in a style not before in use, is issued from the court of this pretended prerogative, during the present times, in the following terms, viz., proved and approved the present testament of A. B. who had, whilst he lived, and at the time of his death, goods movable or removable, spiritual or temporal, rights or debts in divers dioceses, and peculiar jurisdiction of the province of Canterbury, and C. which style no Archbishop of Canterbury ever used, nor did any Archbishop of Canterbury, before the time of Archbishop John Morton, usurp the probate of the testaments of persons belonging to the dioceses of their suffragans, unless in that case only, when the person so dying, left, at the time of his death, bona notabilia in another diocese, than that in which he died, although it is altogether unknown to the suffragans by what right he pretended that this belonged to him. Nor can the suffragans sufficiently express their wonder from whence this prerogative derived its origin, unless only from a violent and clandestine usurpation, when it evidently appears, that, during the time of Octobon, formerly the legate of the Apostolical See in this kingdom, this prerogative was altogether unknown. For in the time of the aforesaid legate, a controversy arose amongst the bishops of the province of Canterbury, to which should belong the probate of the will of a beneficed clergyman having benefices in divers dioceses, and dying in one of them, and the doubt was referred to the decision of the legate, who decided that the probate should belong to the bishop, in whose diocese the beneficed clergyman should die. Besides, in the time of John Stratford, formerly Archbishop of Canterbury, such prerogative was unheard of, when, in a provincial council of Canterbury, over which he presided, as its head, and with the consent of the bishops and prelates, and clergy of the said province, he declared that the approbation and insinuation of testaments, and the distribution of the goods, as well of the clergy's laity, dying within the province of Canterbury, belonged to the ordinaries of the places in which they died. After which council many others have followed, over which the Archbishop of Canterbury for the time being always presided, and he had power from time to convoke such a council. Nor has any Archbishop of Canterbury moved or proposed for the retraction or revocation of the said constitution, in which the premises are declared to belong to the ordinaries of the places, nor attempted to agitate any question concerning the right of the bishops to the possession of this authority, nor in any council procured to be passed any order or new constitution concerning the probate of testaments and administration of goods, upon the aforesaid constitution, which the said John Stratford, one of the archbishops themselves, made and promulgated, and which his successors by not revoking, knowingly and prudently approved, and supported the bishops in persevering in the possession of, according to the tenor of the aforesaid constitution, until the time of John Morton, who, within the last 14 years, died whilst prelate of the Archbishopric of Canterbury. And it is moreover to be noticed, that when the Most Reverend Father, the present Archbishop, Wareham, was Bishop of London, he commonly proved the testaments of all persons dying within his diocese, having goods in divers dioceses of the province of Canterbury, even to the sum of £5, and something more, and something less, as evidently appears from the registers of the Church of London, made during the time of his presiding over the diocese. This complaint, therefore, on the part of the suffragans, was supported by the acts of the then Archbishop of Canterbury, whilst he was Bishop of London, thus uniting the testimony of the whole province of Canterbury to the authenticity of their representations. The year after this complaint, Henry VIII, displeased with the disorders occasioned by the long continuance of this controversy, in synod and at Rome, for it had been in litigation 2 centuries, interposed, and brought things to temper. His letter, upon this occasion, to the archbishops and bishops, shows the importance of the controversy. Right Reverend Fathers in God, right trusty and well beloved, we greet you well, not doubting but that you have in your good remembrance, that where we have knowledge that there was a plea and process commenced and hanging in the court of Rome, by twixt you on the Owen party, and the Most Reverend Father in God, the Archbishop of Canterbury, on the other party, for the jurisdiction, power, and authority that he pretendeth to have in certain cases, to and for the approbation of testaments within your dioceses, not only to your and his manifold inquietations, costs, and troubles, but also in a great party, to the manifest division and dissension of the universal Church of this our Rome, for so much as the said matter concerneth and toucheth the same. Then follow his directions as to the Archbishop's claim, and the letter concludes, this, our commandment and ordinance, to endure only by the space of 3 years next coming, after the date of these our letters. And if, during the same time, there shall forthune any doubt or difficulty to rise betwixt you and the said Most Reverend Father in God, in, of, or upon any matter, word, or sentence contained in our said ordinances, or any part of the same, we will that the interpretation and construction thereof be referred only to us, and such of our council as we heretofore deputed to be arbitrators. This letter of the king brought the archbishop and bishops to terms, and they entered into a composition to the following effect, that the prerogative should not attach to any other goods of a deceased, than those which are called by the ancient English name of chattels, if those goods may be known by the denomination of chattels, which a person may dispose of by his will, and that the sum upon which the prerogative may be exercised, should be £10 out of the diocese in which the deceased may have died. And, lastly, although the goods of the deceased to that sum may be divided in divers peculiar parishes, unless, however, those goods shall be situated in the peculiar parishes that are reserved to the Church of Canterbury throughout the divers dioceses of the province of Canterbury, the prerogative shall not be used. The Act of 23 Henry VIII, c. 9, was passed to regulate the ecclesiastical jurisdictions, and more particularly those of the Archbishop of Canterbury, as appears by the preamble of the Act. And it enacts that no manner of person shall henceforth be cited or summoned, or otherwise called to appear by himself, or herself, or by any procurator, before any ordinary, archdeacon, commissary, official or any other judge spiritual, out of the diocese or peculiar jurisdiction where the person which shall be cited, summoned, or otherwise, as is aforesaid, called, shall be inhabiting or dwelling at the time of awarding or going forth of the same citation or summons, except that it shall be for, in, or upon any of the cases or causes hereafter written, that is to say, for any spiritual offence or cause committed, or done, or omitted, forslewed or neglected to be done, contrary to right or duty, by the bishop, archdeacon, commissary, official or other persons having spiritual jurisdiction or being a spiritual judge, or by any other person or persons within the diocese or other jurisdiction whereunto he or she shall be cited, or otherwise lawfully called to appear or answer. And the reservation in favour of the archbishop is as follows, provided, also, This act shall not extend in anywise to the prerogative of the most reverend Father in God, the Archbishop of Canterbury, or any of his successors, of or from calling any person or persons out of the diocese where he or they be inhabiting, dwelling, or resident for probate of any testament or testaments, anything in this act contained to the contrary notwithstanding. This act, prohibiting the citation of all persons out of their own dioceses or peculiar jurisdictions, but reserving to the Archbishop, in respect of his prerogative, the right of citing out of a diocese only for probates of testaments, leaves him no power, in respect of such prerogative, of citing any one, for probate of testament, out of any peculiar jurisdiction, but his own. The Archbishop's prerogative was defined by the composition of 1513, that fixed the prerogative right to the probate of wills, and c. of persons leaving goods in divers dioceses of the province of Canterbury, or divers peculiar jurisdictions belonging to the Archbishop of Canterbury. The Archbishop wanted only the reservation of a right to cite out of a diocese, having an original right to cite out of his own peculiars, and no right to cite out of any other peculiars was reserved to him, because such right did not belong to him. The authenticity of the statement, contained in the Antiquitates Britanniae Ecclesia, of the composition of 1513, must be indisputable from the circumstance, that the book containing it was written by Dr. Parker, who was Archbishop of Canterbury from 1559 to 1573, and was published about the latter year. And the sentence, immediately following the description of the composition, is worthy of particular notice, as stating that the controversy, so often excited between the Archbishop of Canterbury and the suffragans of his province was set at rest for ever, and conveys the strongest assurance, that the composition was always acted upon in his time, and must have continued to be so, until the establishment of the Canons in 1603, into which it was embodied. The Act of 25 Henry 8. c. 19, authorizes the King to nominate 32 commissioners who were to have authority to view, search, and examine the canons, constitutions, and ordinances theretofore made by the clergy of the realm, and such of them as the King's Highness, and the said 32, or the more part of them, should deem worthy to be continued, kept, and obeyed, should be from thenceforth kept, obeyed, and executed, within the realm, so that the King's most royal assent under his great seal be furnished to the same, and the residue of the said canons, constitutions, and ordinances provincial, which the King's Highness and the said 32 persons, and the more part of them should not approve and judge, or deem worthy to be abolite, abrogate, and made frustrate, should from thenceforth be void and of none effect, and never be put in execution within this realm. Provided, also, that such canons, constitutions, ordinances, and synodals provincial, already made, which be not contravenant or repugnant to the laws, statutes, and customs of this realm, nor to the damage or hurt of the King's prerogative royal, shall now still be used and executed as they were upon the making of this act, till such time as they be viewed, searched, or otherwise ordered and determined, by the said 32 persons, or the more part of them, according to the tenor, form, and effect of this present act. It is true a review was appointed, but such difficulties were found in it, as to the shaking of the foundation of the ecclesiastical laws here, that nothing was ever legally established in it, and, therefore, this proviso is still in force. In the statute of 25 Henry 8. c. 21, it is said, that this realm, recognizing no superior under God but the King, hath been and is free from subjection to any man's laws, but only to such as have been devised, made, and observed within this realm for the wealth of the same, or to such other as by the sufferance of the King and his progenitors. The people of this realm have taken of their free liberty, by their own consent, to be used amongst them, and have bound themselves by long use and custom to observance of the same, not as to the observance of the laws of any foreign prince, potentate, or prelate, but as to the customs and ancient laws of this realm, originally established, as laws of the same, by the said sufferance, consent, custom, and none otherwise. This statute of 25 Henry 8. c. 21, is a full confirmation of all canons, constitutions, ordinances, and synodals provincial, that had been theretofore made by the clergy, and although there is not any canon, constitution, ordinance, or synodal provincial, for the establishment of the prerogative court, yet inasmuch as the composition of 1513 was entered into between the archbishop and suffragans, in consequence of a recommendatory letter from King Henry VIII, and as the prerogative right of the archbishop to the probate of wills is recognized by 23 Henry VIII. c. 9, the constitution of the prerogative court, as it then existed, must be deemed to have been fully established. The only canons relating to testamentary jurisdiction are the 92, 93d, and 94th, and they were intended, no doubt, to render the jurisdiction of the prerogative and diocesan, and inferior courts, so distinct, that no question should, for the future, arise, as to their respective rights, but they expressly relate to the archbishop's courts. The summary of the 92d canon is, that if any person shall die, having, at the time of his death, goods or good debts, in any other diocese or dioceses, or peculiar jurisdiction than in that wherein he died, amounting to the value of 51, the probate of his will or the administration to his effects, shall be granted by the prerogative court, and any probate or administration, in such case granted by any other court, is declared to be frustrate and void. The following proviso is contained in the canon, provided always that this present constitution, or anything contained in it, shall not be prejudicial to any composition that has been made between an archbishop or any bishop or other ordinary, nor to any inferior judge, who shall grant a probate of a testament or administration of effects to any person, spontaneously and of his own accord, requiring a probate or administration, as well from the inferior court as from the prerogative court. This canon, therefore, declares all probates and administrations granted by a bishop, or other ordinary, to be void in cases of bona notabilia, unless the party to whom the probate or administration shall be granted, shall voluntarily require a probate or administration from the inferior as well as from the prerogative court. Therefore, until the wish of the person proving the will, or requiring the administration, is expressed, it would be premature to declare to be void any probate or administration, that may have been granted by an inferior court, where there are bona notabilia in another diocese. The 93d canon decrees and ordains that no judge of the archbishop's prerogative, should thenceforth cite or cause to be cited ex officio, any person whatsoever to any of the aforesaid intents, unless it should previously appear to the same judge, that the deceased had during his life, and at the time of his death, goods or chattels to the value of 51. In any other diocese, or dioceses, or peculiar jurisdiction, situated within the same province, than that wherein he died, to the value of 51. And it was by the same canon declared and pronounced, that he, who had a less sum in such a case, had not bona notabilia. The following is the 94th canon: no dean of the arches, nor official of the archbishop's consistory, nor any judge of the audience, shall henceforward, in his own name, or in the name of the archbishop, either ex officio, or at the instance of any party originally, cite, summon, or any way compel, or procure to be cited, summoned, or in any way compelled, any person which dwelleth not within the particular diocese or peculiar of the said archbishop, to appear before him, or any of them, for any cause or matter whatsoever, belonging to ecclesiastical cognizance, without the license of the diocesan first had and obtained in that behalf, other than in such particular cases only, as are expressly accepted and reserved in and by a statute, anno 23 Hen. 8. Ch. 9. These three canons conjointly regulate the testamentary jurisdiction, and being so intimately connected, an ambiguity in any one of them should be explained by the other. Blackstone, in his Ad volume of Com. p. 89, lays down as a rule in the construction of deeds, that the construction be made upon the entire deed, and not merely upon disjointed parts of it. For the best interpretation is to be collected from the antecedent and subsequent parts. There is an ambiguity in the 92d and 93d canons, as to the meaning and extent of the words peculiar jurisdictions, For to the peculiars belonging to the king and to those formerly belonging to monasteries, they cannot apply. The ambiguity may be most reasonably explained by considering the peculiar jurisdiction of the 92d and 93d canons, and those of the 94th canon to be the same. And this construction is established by the reenactment of the Statute of 23 Henry 8, c. 9, in this last canon, which statute, whilst it prohibits the citation of any person whatsoever out of the diocese or peculiar jurisdiction, in which he dwells, reserves to the prerogative of the archbishop the right of citing any person out of a diocese for probate of a testament, and reserves no right to the archbishop to cite out of any peculiar jurisdiction, thus proving that the prerogative extended not over any other peculiar jurisdiction than those belonging to the archbishop. And when, in addition thereto, it is considered that in the dispute of 1319, the archbishop claimed the right to probate when goods were left in divers dioceses or other places, belonging to the Church of Canterbury, the present peculiars of the archbishop, and further, that in the composition of 1513, the prerogative was limited to the archbishop's peculiars, no other can have been contemplated by, or included in, the 92d and 93d canons, of 1603, than the archbishop's peculiars. And, in that case, the Statute of 23 Henry 8, c. 9, and these canons are consistent with each other, but, if these canons should be deemed to include other peculiars than those of the archbishop, they allow to the archbishop an interference with peculiar jurisdictions, which that statute prohibited, and, as canons not confirmed by Act of Parliament, cannot, according to the following case, alter the statute law. The 92d and 93d canons cannot be construed to allow to the prerogative court any right over peculiar jurisdictions, which that statute of 23 Hen. 8, c. 9, prohibited. Lord Chief Justice Vaughan, in the case of Grove and Dr. Elliot, Chancellor of Sarum, 2 Ventris Report, 44, adjudged that the canons 3 Jacobi, certainly are of force, though never confirmed by Act of Parliament. Indeed, no canons of England stand confirmed by Act of Parliament, yet they are the laws which bind and govern in ecclesiastical affairs. The Convocation, with the licence and assent of the King, under the Great Seal, may make canons for regulation of the Church, and that as well concerning laics as ecclesiastics, and so in Linwood. Indeed, they cannot alter or infringe the common law, statute law, or King's prerogative. The canons of 1603 were confirmed by King James, and as far as they relate to testamentary matters, received a further confirmation from the Statute of 29th Charles II. c. 3, s. 24, which is as follows: "And it is hereby declared, that nothing in this Act shall extend to alter or change the jurisdiction or right of probate of wills concerning personal estates, but that the prerogative court of the Archbishop of Canterbury, and other ecclesiastical courts, and other courts having right to the probate of such wills, shall retain the same right and power as they had before in every respect, subject, nevertheless, to the rules and direction of the Act."